The next case on the docket is Walsh versus Bank of New York Mellon Trust. Counsel, you may proceed.
May it please the court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
Okay.
Your Honors, it's clear that reversal has to happen here. My opponent concedes as much. So my arguments are essentially what issues which we should be reversing on and what the remedy should be on remand as a result of that reversal.
And in your initial brief, what did you argue the relief should be on remand?
In the initial brief, I argued for an involuntary dismissal. Unfortunately,
correct?
Well, the meat of the brief didn't specify. The conclusion paragraph, which I had frankly copied and pasted from a different brief, said without prejudice, unfortunately. So I wasn't going to spend too much time arguing about that distinction. I think that the first issue I wanted to talk about is an issue that happens a lot in these cases that my opponent didn't even have a contrary argument to. It's not my best argument or the biggest issue, but it's one I don't want to miss in my time here, and that is on attorney's fees. The lower court awarded attorney's fees in the final judgment without any evidence at all on them, without any expert testimony, without any evidence whatsoever. And this happens, unfortunately, a lot. I do in my foreclosure defense practice, where the plaintiff comes into trial with a form final judgment, hands it to the court, and if the court rules in the plaintiff's favor, then the judgment just gets signed, even without any discussion or evidence on attorney's fees. My opponent didn't even brief the issue of attorney's fees being improperly included, so I submit the first thing this court should be doing is reversing the inclusion of attorney's fees and having a written opinion that I think will be useful for trial judges to remember and realize you can't just sign the form that gets submitted to you even if you're ruling in the plaintiff's favor that includes attorney's fees when there's no evidence at all to support them. And I also cite cases in the brief for the proposition that that should be without remand, because when there's no competent substantial evidence about attorney's fees at all presented initially, then the reversal is without remand. So that should be the first reversal.
Let me ask you about another attorney fee issue.
Yes, John.
You've asked for appellate attorney's fees, right?
We did, Judge.
It's your position that the plaintiff below failed to establish standing with regard to the note and mortgage, correct?
That they failed to establish standing at the inception of the case. We acknowledge that the plaintiff proved standing at the time of trial. It was standing at the inception of the case is the loan defect. So if you're asking if the court should be following the Third District's recent decision, the answer is no for a variety of reasons. If you're interested in that issue, I'd love the chance to brief it, but the one obvious distinction is that we're only challenging standing at inception. Standing at trial was established, so there was contractual privity between these parties. The Third District case that Your Honor is alluding to also, where I think that's clearly wrongly decided, and I have Second District decisions, including the Second District when they went in bank in my favor in the Corrigan case, they awarded fees for me on a standing case, even where the other side argued the HFC decision. And I think the rationale for that is because the reason to not award fees is where there's an estoppel, where a defendant in my situation comes into trial and presents affirmative evidence in order to prove a lack of standing, like that's not my signature on the note, or that's forged, or something like that. Those are the cases that are set forth in that Third District's decision that justify not awarding fees under the reciprocity provision of 571057. Respectfully submit that fees are required and are authorized in a context like what we have here, where the plaintiff simply didn't prove their prima facie case. We didn't put on evidence inconsistent with standing. They simply didn't prove their prima facie case. For example, if there was a notice of voluntary dismissal, certainly we would get fees for that. If there was an involuntary dismissal taken at a trial where the plaintiff presented no evidence at all, certainly we would get fees for that. We would also certainly get fees in the event of an involuntary dismissal where the plaintiff simply didn't prove its prima facie case, because that's not us presenting evidence that there was no contract, where we would be barred by estoppel because we affirmatively proved the lack of a contract. That's simply enforcing the reciprocity provision of 57105 that says, hey, if the plaintiff wins and gets fees, which they undoubtedly do if they win, then we, as the defendant, also get fees in the event that we win. So I think all the cases...
Wasn't that the argument that was not accepted in HFC?
Well, no, I don't think that was the argument that was not accepted in HFC. I think that the HFC line of cases all stand for the proposition that where the defendant presents affirmative evidence that there was no contract, that's the dispositive distinction, Your Honor. So forgive me, I wasn't anticipating this questioning, but I do appreciate the opportunity to talk about it. I think that's clearly the dispositive distinction, is that in the line of cases that the Third District relied upon, those are all cases where the defendant presented some affirmative proof or testimony that there was no contract. So they say, well, where you proved there was no contract, where you proved it was forged, or you proved you weren't a party to it, you should be stopped from now coming in and getting fees under that contract. That's much different than where the plaintiff doesn't meet its prima facie case. Like by way of example, let's say that you come to trial and the plaintiff puts on no evidence at all to support a standing claim. Okay, no evidence at all to support a standing claim. Does the defendant not get fees in that situation? The defendant isn't stopped. The defendant didn't put on any evidence. The plaintiff just didn't prove their case. How is that not just a straightforward example of the reciprocity provision in 57105(7) applying? That's why every time that I have won an appeal in a foreclosure case in a Florida DCA, even on standing, and it's happened like 5 or 6 times, I've been awarded fees even when the other side had argued HFC. It's unfortunate that there's been no written decision yet on that issue, but if you're interested in writing on it, I'd love a chance to brief and explain the issue. I also think there are Florida Supreme Court cases that you can't reconcile the Third District's recent decision with. The Florida Supreme Court says even when a contract has been rescinded, that there's still fee entitlement under the reciprocity provisions of 57105(7). So I definitely think that we're entitled to fees for all those reasons, and as I indicated, if you want to write an order giving me a chance to write a brief on that, I'd love the opportunity to do so. In terms of the merits of this case, the plaintiff did not prove standing at the inception of the case by documentary evidence. This court's precedent in Schmidt and Gonzalez makes it very clear that they had to prove standing via documentary evidence. That didn't happen. Even when I highlighted that principle of law in the initial brief, my opponent came back in the answer brief only with, well, here's what the witness testified. That's it. Okay, well, where was the documentary evidence? The only documents and evidence that in any way could have touched on this issue were the power of attorney and pooling and servicing agreement, because remember, the note attached to the complaint was not endorsed. So you have a note attached to the complaint that's not endorsed. Then you have a power of attorney. The power of attorney postdates the filing of the suit. So under Russell and Lacombe, that doesn't help the plaintiff at all prove standing. So that not only leaves the pooling and servicing agreement, PSA, several reasons why the PSA did not support standing at the inception of the case. The first is that the pooling and servicing agreement should not have even been admitted into evidence at all in the face of our contemporaneous hearsay objections. The PSA was not a business record. The other side, the witness did not even attempt to lay the 4 prongs to the business records exception of the hearsay rule at or near the time of the event by a person with knowledge. Nothing like that at all. So it wasn't admissible under the business records exception, and it wasn't admissible under the public records exception because it was just printed off of the internet, printed off of a government website, which was undisputed and was shown by the electronic signatures on the page. There's 2 DCA decisions that I use for this proposition, one called Whitley and one called Gray, both out of the first DCA. The Whitley case, I think, is telling because there it was a document printed off of a government website, the exact same issue that we have here. In that case, I think it was a Department of Corrections website. Printing a document off the Department of Corrections website did not make the document admissible into evidence without a records custodian there to authenticate it. It's hearsay. Now, there's simple ways around this issue in a foreclosure trial. A PSA could be admissible, you could avoid the hearsay problem by having it be a certified copy, perhaps, or by laying the prongs to the business records exception to the hearsay rule. That didn't happen here, so the PSA didn't help them for that first reason. The PSA also didn't help them because there was no evidence at all to show a conveyance to the depositor. The depositor under the PSA was a company called MARS, M-A-R-S is the acronym. That company was not even mentioned in any way at trial, not mentioned in the trial transcript, not mentioned in any of the exhibits itself, other than the PSA itself. And there are several cases which stand for the proposition that without proof of a conveyance to the depositor, a PSA just doesn't do anything. Now, I know that you can't argue about a PSA in a panel with Judge Palmer without talking about the Marciano case. Marciano is not inconsistent with that proposition because nothing in Marciano talks about the proof of a conveyance to the depositor. And so Marciano is consistent with this argument in all the other cases that I've presented, Murray, Safar, Hepworth, in that you had to have proof of a conveyance to the depositor because otherwise there's literally nothing to convey. Because the purpose of a PSA, and what Your Honor emphasized in the Marciano decision, was that under a PSA, paragraph 2.01, the depositor conveys assets into the trust. Okay. Well, if nothing was actually conveyed to the depositor, then the depositor has nothing to convey to the trust as a matter of law. That's what the Fourth ECA first held in Murray, and several decisions following it have held Hepworth as well. Here, the plaintiff just didn't meet this element of its prima facie case sufficient for the PSA to do anything because there was simply no evidence at all of a conveyance into the depositor. I think it's telling that my opponent really doesn't even argue these two issues about the PSA at all. They don't argue the admissibility issue at all. They don't argue how there was no proof of a conveyance to the depositor at all, or the line of cases that I presented. They didn't even mention the Marciano case. I mentioned that because, you know, it's an appropriate thing to do with this court, and Your Honor wrote the decision. But I think it's telling that my opponent doesn't even have anything to present on those issues with respect to the PSA. Instead, my opponent argues Ortiz, the Ortiz line of cases. I think it's telling that they have to resort to that when Ortiz clearly only applies when the note which is introduced into evidence is in the same condition as that was attached to the complaint. That's very clearly not the case here. The note that was attached to the initial complaint did not have any endorsements, whereas the note in evidence clearly did. So on the face of Ortiz, that line of cases just doesn't apply. And what then applies is this decisions in Schmidt and Gonzalez, which hold that the plaintiff had to prove standing at the inception of the case by documentary evidence, and there's just nothing that does that. The only other argument my opponent then makes is, well, PHH was the original lender, and so it's because it was the same entity as the original lender that somehow proved standing at the inception of the case. There's a couple fatal problems with that argument too. First is that even if those entities were the same, that doesn't mean that PHH was in possession of the note. Being the original lender does not ipso facto create standing. If you look under 673-3011, the Florida statute, which sets forth the three ways that a plaintiff can have standing in a foreclosure case, being the original lender is not one of them. Holder, non-holder in possession, reestablished lost note. That's it. Being the original lender does not ipso facto give you standing in a foreclosure case. You still have to have possession. You have to prove possession of the note. So there had to be some evidence that PHH was in possession of the note when the suit was filed. There was absolutely nothing in that regard. There was no documentary evidence, as this court requires. Even if there was documentary evidence on PHH being in possession of the note, that's not the same thing as the plaintiff trust being in possession of the note under the concept of what the DCAs call constructive possession. I don't believe that this court has issued a decision on the constructive possession concept yet. The second district did in the Fan case, which I explain in detail in the reply brief. The decision that I think is on point is Rosa, which is the second district case that distinguishes Fan, which explains how in Rosa, the note attached to the complaint did not have an endorsement, just like this one, and there was no proof that the servicer possessed the note as an agent for the plaintiff trust as of the time that the suit was filed.
Do we have any other questions for counsel at this point? All right. Why don't you, reserve the rest of your time for rebuttal at this point? I just wanted, to make one just comment on writing style. In your brief, you conclude that the trial judge was obviously confused, which is a little uncomfortable for me when I read something like that in a brief. Good writing shows me that the judge was confused, doesn't tell me that the judge is confused. That's just a personal writing style preference of mine, for what it's worth. Okay.
I appreciate the point, Judge.
Right.
Thank you.
Okay. All right.
So, but if I
No,
can...
we're gonna go ahead and let opposing counsel speak,
Thank you.
as painful as that might be for you.
May it please the court, your honors, my name is Matthew Sisio, and I represent the plaintiff in the lower court action. That's the Bank of New York Mellon Trust. As opposing counsel pointed out, the main issue of this case is standing. And
Was the pooling service agreement properly admitted into evidence, and if so, on what basis?
it was not properly admitted under the grounds that the plaintiff's counsel sought to admit it under sub 90.803 subsection 8 as a public record. And to determine that, the standard review is an abuse of discretion. If the court determines that the lower court abused their discretion in admitting it under that subsection, then I would argue the standard of review to even determine if it's hearsay is de novo. And I would argue that the pooling and servicing agreement is not hearsay because of the 5th DCA's case in Aliqua Deutsche Bank versus Aliqua Properties. In that case, this court ruled that a promissory note was a contract of independent legal significance, which allowed it to escape from hearsay. And in that case, this court also held that this would apply to contracts, wills, and other such instruments as notes. The pooling and servicing agreement, in my mind, is by name alone an agreement. It's a contract. And it could and should have been admitted as a contract of independent.
That's not the argument that was made below, correct?
That argument was not raised below. The only attempt to admit it was through subsection 8 of 90.803. But I believe under this court's de novo review, it can be admitted as non-hearsay because plaintiff should not have had to go through an exception because it was not a hearsay document to begin with, Your Honors.
Walk us through, if you were, how you say this note and mortgage transferred and what evidence you had that your client had standing at the time that they filed the lawsuit.
Yes, Your Honor. First and foremost, the testimony. Opposing counsel points out that there are 2 cases from this court, Gonzalez and Schmidt, that state testimony on its own is insufficient. However, those cases are distinguishable, and all the other DCAs throughout the state have ruled that testimony of a litigation analysis can overcome insufficient documentary evidence. Those cases include May versus PHH Bank from the 4th, Sosa versus US Bank from the 4th, Walton versus Deutsche Bank from the 1st, and Ham versus Nation Star from the 4th.
So you're saying that our cases are not distinguishable, but that we should in-bank and recede from those cases, or is it your position that our cases are somehow distinguishable?
Your cases are distinguishable in the cases where there was only testimony before you and this court found that that was insufficient was because those cases also had contradictory testimony or contradictory evidence. We don't have any of that here. All we have on record site 32 and 82 of the transcript is our witness stating that the note was endorsed in blank prior to the filing of the action. It was possessed by the plaintiff, sent to the servicer, and then sent to plaintiff's counsel for filing of the foreclosure action. There's nothing in the documentary or testimonial during cross or direct that would contradict that. Specifically in Schmidt from this court, when they decided that the testimony was insufficient to establish standing, the witness was unsure regarding possession, and that's a quote from your case. Here, our witness was not unsure. He was certain that the bank possessed it prior to the filing.
What was the basis of his knowledge to make that statement?
Our witness,
Yes.
he based it on an FOR3 screenshot.
Which was not admitted into evidence,
It
correct?
was correct. It was not admitted into evidence, but that testimony, how he knew it and what he knew, was not stricken. Defense counsel did not move to strike it, and it becomes evidence. And there was nothing to contradict the possession of the blank endorsed note filed prior to. Also in Schmidt, there's a post-dated assignment of mortgage that shows at least the mortgage, and I think this court questions maybe the note was also post-dated or post-endorsed rather. We don't have that here. We don't have a post-dated assignment of mortgage, so again, no evidence to the contrary. Also in Schmidt, they initially pled a lost note count. So at the filing of their complaint, they said, we don't have the note, and then they came back at trial with testimony saying, yes, we did. We don't have that here. In our initial complaint, we stated we were entitled to enforce the note, And then at trial, we showed possession and relied on the testimony stating possession.
But it was different than the note that was attached to the complaint, right?
That is correct.
All we know you had by the pleadings that you had at the time of the filing is the note in the form attached to the complaint.
Yes, we can't get through the Ortiz standard, which I believe has been followed by this court. The case escapes me now, but it has been followed where if you attach a copy that's identical to the note that is later tendered at the time of trial, that's sufficient to prove possession. We can't do that here, but I would urge the court take a similar approach, because we have unrebutted, uncontradicted testimony that it was that way. And again, we have no evidence to contradict it. Just like Ortiz, to overcome that, the defendant needs to prove, or at least establish through some testimony or documentary evidence, that it was not endorsed in blank. They did not do that here. And that goes back to the Gonzalez.
Why do they have a burden to prove that?
Because we had evidence showing we did. We have the testimonial evidence from our witness stating it was endorsed in blank prior to the filing of the complaint, and specific steps of who it went to. And that is evidence because it was unrebutted and not objected to, and the defendant did not move to strike it at the time that the testimony was elicited. And then that takes me to the Gonzalez case. That's the second case from this court. In that case, the witness contradicted herself. After she had stated that the plaintiff owned the note or was blank endorsed prior to, she later said Fannie Mae was the owner. So she had contradicting testimony of her own, which the court specifically points out in their opinion. Again, we don't have that here. Our witness's testimony was clear, uncontroverted, and had nothing to the contrary.
How do you address opposing counsel's argument about attorney's fees below, that there was no proof of them, and that if we were to send it back, that you don't get a second chance to prove attorney's fees?
Well, I think we definitely do, and we originally, as your honors know, confessed error based on this issue because the trial attorney did not ask the proper questions to get the loan payment history admitted under 90.8036. However, right around that time, several cases came out that stated so long as a prima facie case is established and damages are shown, the proper remand is to go back to the trial court.
I think Judge Palmer is asking about attorney's fees, about the proof of attorney's fees below.
Oh, entitlement to attorney's fees?
Proof, the evidence, that there was no evidence presented as to reasonable hours spent, reasonable hourly rate, and yet the trial judge awarded attorney's fees.
We did provide affidavits stating the reasonableness of those attorney's fees, but it's my position that that point is moot, and that's why I didn't address it in the brief, is because there's only two options here. There's remand with involuntary dismissal, and there's remand to properly calculate the damages. So that's what the appellee is looking for. We're seeking to affirm the final judgment and go back to the court and then establish all the damages, which would include unliquidated damages such as attorney's fees. So the issue of it, and if the appellant is successful, it's an involuntary dismissal, so that the attorney's fees does not apply here.
All right. Any further questions?
Just, if I may, Your Honor, one more point about the documentary evidence. I believe we had sufficient evidence through the testimony, but I'd like to turn the court's attention to the mortgage loan schedule, which is a separate document from the PSA. And of course, the Marciano case holds something specific outside of the PSA. In Marciano, the mortgage loan schedule reflected the date the plaintiff trust received possession of the note. And I've looked at many mortgage loan schedules, and I think that is a rare occurrence. We have that here. It's a little hard to see because this is a large document and the numbers are all, it's just numbers. But the Walsh loan, the subject loan before the court, under every subsection is 10 steps down. So this is record page 302. If you go 10 steps down or 10 lines down from the top that has all the descriptions, it will show the date that the note was executed, which is 12/16/2004, And then it also has a column titled the note received date. The note received date reflects 12/28/2004. That's possession, and that's documentary evidence. And that goes with our testimony. And in its totality, we've proven by a preponderance of the evidence that we possess the blank endorsement.
What's the document you're reading from?
This is the mortgage loan schedule. It's record number 302. It was admitted, I believe, as Exhibit 7 in the trial court. And I think in Marciano, this is a very similar mortgage loan schedule, and that was pointed out. In fact, in the Marciano opinion, this court said, when discussing the PSA, moreover, the PSA contains section 2.01. The most important part of the Marciano opinion was the mortgage loan schedule that reflected possession, which we have here in our mortgage loan schedule, Your Honors.
And that reflected possession when?
As of 12/28/2004, that the trust possessed the note. And then we had testimony that the trust did not send the note to the servicer until the filing of the foreclosure occurred. And then in addition to that, to the extent the court can consider the pooling and servicing agreement under ALACWA as a contract of independent legal significance, that document has a cutoff date of February 1st, 2005, which would coincide, excuse me, with the date that the note was sent to the trust. And also, section 2.01 is very similar to 2.01 in the Marciano case. And there has been additional case law. Around the time of the briefs, Marciano was a brand new opinion. I think it was issued by this court during the pendency of our briefing stage. Since then, the Fourth has agreed with that case in the U.S. Bank v. Bolus matter. Excuse me. I don't believe there's a citation to that. It was just final. It was on a rehearing, but it stands for the same proposition. In fact, in that case, they didn't have a mortgage loan schedule with the specific possession date, but section 2.01 that showed, or the terms of that document, reflected that the note must be introduced into the trust in a blank endorsed condition, was enough for the plaintiff to establish standing at commencement of the action.
All right, thank you, counsel.
Anything further, Your Honors?
No, sir.
Thank you very much.
All right, brief rebuttal.
Please, the court. I concentrated on the standing issue because that does require a dismissal on remand in the event that you agree with me. I do think that the second issue does as well, by the way, the issue that they confessed error on the payment history shouldn't have been admitted into evidence. But on this, to rebut on this.
Would you address the argument that the testimony which you say is inadequate was not objected to or moved to be stricken, and does that matter?
I don't think it matters because this court's binding precedent in Gonzalez and Schmidt all requires documentary evidence and holds that bare testimony without the documents is insufficient. So what my opponent is asking you to do is contravene your own precedent. That was his argument. Obviously, you shouldn't be doing that. I also think that we made contemporaneous objections to that testimony. For instance, I have page 81 of the trial transcript here, where the witness was asked if the plaintiff had possession of the note at the time prior to the suit, and we have not only objected on hearsay, saying that they have to have a business record, but cited a case called Sass versus Fannie Mae, a second district case, which holds that testimony based on the content of documents, not in evidence, is inadmissible hearsay. And I submit that's the reason why this court employed the standard that it has in Schmidt and Gonzalez, is because we shouldn't be allowing these witnesses in foreclosure cases to testify about the content of documents that aren't in evidence. Now, my opponent...
What's the record site for what you were just quoting from?
Page 81 of the trial transcript.
Thank you.
It's on lines 17 through 20 is our objection. I think you'll see there we even said again under Sass versus case. That was under Sass. That was a case that we had been presenting throughout to illustrate the proposition that you can't testify about the content of documents not in evidence. That's inadmissible hearsay. And that Sass case has a long string cite within it of cases that support that proposition. So one, I don't think that we needed to do a motion to strike or anything like that under this court's precedent. we were allowed to rely on that and simply say they had to have documentary evidence and they didn't have it. But I also think that we were making contemporaneous objections throughout, and that was one good example of that. So I don't think the witness testimony helped save their case on standing. I don't think that the PSA helped save their case either. My opponent argues for the first time at oral argument, it wasn't argued either below or in the briefs, that the PSA somehow is an act of independent legal significance and is hence non-hearsay. There's no way to reconcile that with that argument which is tellingly made without any case citations. With the cases that I presented, Whitley and Gray, you can't just show up with a document that you printed off the internet and say that that's automatically admissible. It's just not. It doesn't even matter where the document came from. That's why my Whitley case, which it's telling my opponent doesn't even mention, is right on point. That was printed off of a government website as well, and it was deemed not admissible without a records custodian and without a certified copy. So there's simply no way around that. I think it's also telling that my opponent, even though I highlighted it and emphasized it and cited cases supporting it, totally ignored the concept of proof of a conveyance to the depositor. Instead, he talked about other aspects of the PSA, but he ignores the fact that the depositor can't convey anything to the trust if there was no conveyance to the depositor. I ask that your honors look at the note. The note has two entities on it. There were the original lender to one entity, Bishops, I believe, and then Bishops and blank. None of those entities were in any way involved in the PSA, not in any way. And Mars was not in, the depositor under the PSA wasn't mentioned on the note in any way or on any of the endorsements. So where's the proof of any sort of a conveyance to the depositor? There isn't one. So there's no way to reconcile my opponent's position with this court's decision in Schmidt or Murray or Safar or Hepworth, all of which require proof of a conveyance to the depositor. And the Marciano case that he relies upon it does not address that issue, so it's distinguishable on that basis because it just doesn't talk about proof of a conveyance to the depositor. So that is required under all the cases.
Do we have any further questions from the panel? All right, thank you both for your presentation. We're going to take a recess at this time, meet with the lawyers if they'd like, and we'll be in recess for that.
Thank you.